Stand. We want to make sure the Capitol Police remains in the room, just in case we have any other concerns. The gentlelady from Washington is recognized.
Thank you, Mr. Chairman. I have a unanimous consent request.
Gentlelady is recognized.
This is an order of the D.C. Circuit dated December 8th, 2023, in which the court recognizes that Donald Trump's statements about the judge and his case have led to threats against the judge, where callers labeled the judge and clerk, quote, Nazis, dirty Jews, and child molesters, and represent, quote, Mr. Trump's documented pattern of speech and its demonstrated real-time, real-world consequences pose a significant and imminent threat to the functioning of the criminal trial process in this case.
Without objection. A lot. And the gentleman from Colorado is recognized for 5 minutes.
Thank you. Mr. Smith, thank you for being here. Thank you for your service to our country. My colleague from Virginia, who's a Republican colleague who was questioning you right before the break, do you know what he said in the days after January 6th? Let me share this with you. This is a quote of his from a press release on January 8th. Congress stands united in our rejection of the violence that occurred this week, and I'll continue to urge the swift prosecution of those involved to the fullest extent of the law. Mr. Smith, this is theater. Republicans are trying to rewrite history. That's what this is. Many of them were with us in the House chamber on January 6th. I remember it well. The chairman was there, as was I. There's been a lot of discussion about witnesses today. Perhaps the chairman could muster the courage to call the 4 witnesses who I see, the American public may not see, I see standing behind you, Mr. Smith, the 4 police officers who risked everything, life and limb, to do what? To protect the Republican members on the dais. It's an outrage that they now sit here and have the audacity to try to rewrite history in front of the very officers who sacrificed everything to protect them. Mr. Smith, you're of course aware that President Trump was impeached for his conduct connected to January 6th, right?
Correct.
Do you know how many members of Congress voted to impeach him?
I don't recall.
232. Do you know how many Republican members of Congress voted to impeach him?
I don't recall.
10 Republican members of Congress voted to impeach him for his conduct related to January 6th, including at the time the sitting Republican chairwoman of their conference. There was a trial in the United States Senate. Senators sat as jurors. I remember it well because I was one of the prosecutors who prosecuted that case. Do you know how many senators voted to convict President Trump of high crimes and misdemeanors during that trial, Mr. Smith?
I don't recall.
57 senators. Do you know how many Republicans voted to convict him?
I don't recall.
7 Republican United States senators voted to convict President Trump of high crimes and misdemeanors. It was the most bipartisan vote for conviction of a president in the history of the Republic. So they can engage in as much histrionics as they want to try to rewrite history. But facts are facts. They talk about weaponization. They accuse you of weaponization of the justice system. While the Federal Reserve Board chairman rings the alarm about political retaliation by this Department of Justice. Mr. Smith, I don't know if you're aware of this. I don't know if your counsel has made you aware that President Trump is live tweeting, I guess you call it truth socialing, as we speak. Are you aware of this, about this hearing?
No.
Let me read to you what he posted an hour and a half ago. Deranged Jack Smith is being decimated before Congress. It was over when they discussed his past failures and unfair prosecutions. He destroyed many lives under the guise of legitimacy. Jack Smith is a deranged animal who shouldn't be allowed to practice law. If you're a Republican, his license would be taken away from him, and far worse. Hopefully the Attorney General is looking at what he's done. We have a word for this. It's called weaponization. It's called corruption. Mr. Smith, if you care to respond, I'll give you an opportunity. But I will simply say we are grateful for your service to this country. We appreciate your fidelity to the rule of law. And I would echo the comments that have been made by my Democratic colleagues to ignore the noise that you hear from so many of my colleagues who would debase themselves in this way. It is, in my view, subversive of the oaths that we took to defend the Constitution. I'm happy to give you an opportunity, Mr. Smith, if you'd like to respond.
I don't have anything to add.
Thank you for your service. I yield back.
Gentleman yields back. The gentleman from Wisconsin is recognized.
Thank you, Mr. Chairman. In 2010, Mr. Smith, did you work for the President Obama's Department of Justice?
Yes, in 2010, I was the chief of the Public Integrity Section.
During that time, did you have any contact or connection with Lois Lerner with the Obama IRS?
Yes, I was new to the Public Integrity Section. I was the chief. I was trying to learn about issues I had not been at.
Did you attempt to work with Lois Lerner and the IRS to investigate nonprofits?
What I did was I asked for a meeting with the IRS about nonprofits.
So the simple answer is yes. Correct.
Well, I didn't ask to work with Ms. Lerner. They sent Ms. Lerner. That's the person who came to this meeting. I met her once.
And they went after Second Amendment groups, correct? If you remember correctly, that's what was the offshoot of it, that Second Amendment groups that tried to gain nonprofit status, they were slow-rolled through the IRS. Do you recall that?
Separate from this, there was an investigation of that that I was a part of in Public Integrity.
Did you, you prosecuted Virginia Governor Bob McDonnell. This was asked earlier. You prosecuted him, correct?
I was part of the prosecution, yes.
And that ended up with that decision ended up being unanimously overturned by the Supreme Court, correct?
That is correct, sir.
Yeah, including Justice Ginsburg joined in on that opinion, correct?
I believe that's correct.
Yeah. You also prosecuted John Edwards and Bob Menendez, and those both ended in mistrials. Is that right?
The John Edwards case did. The Menendez case, I had left the Public Integrity Section by the time that case was tried. I wasn't.
So, Mr. Chairman, what we heard from the other side here is that this gentleman is the gold standard for prosecution here in the United States. So think about it. We had a witch hunt done by the IRS going after Second Amendment groups, unanimously overturned by the Supreme Court. Prosecuted two prominent political figures, and they ended up as mistrials. That's the gold standard here in America. I would just say this, Mr. Chairman. If Mr. Smith ever works for the Department of Justice again, I would recommend a remedial course on the First Amendment to the Constitution. Before I yield the rest of my time, Mr. Smith, I just have one other question. Is there any historical precedent for an alternate slate of electors to be sent to Congress? Has that ever happened before?
That had happened, not anything similar to this situation, but you're correct. It was in Hawaii. I think it was Hawaii in, I want to say, the 1960 election.
So it has happened before that there was an alternate slate of electors that was sent to Congress, which does the electoral count, correct?
There was a prior time that an electoral slate was sent where there was litigation and recounts going on.
Actually, there's twice that it happened, Mr. Chairman. It happened in 1876 and 1960 that these alternate electors happened. I'd like to ask unanimous consent to introduce the 1960 Hawaii case.
Objection.
Here. With that, I yield to the chairman.
I appreciate the gentleman yielding. The gentleman from Colorado talked about noise from this side. It's not noise, it's facts. The fact is, you approved a $20,000 payment to a confidential human source. And I think you said earlier the reason this individual or entity or person was paid was to review photo and video evidence. Why'd they have to be confidential? Why didn't you just contract with them?
My understanding is that this person was a confidential human source with the FBI. I do not know why they were confidential, but it would make sense to me, given that this person was assisting.
Well, confidential just raises the question of what were you trying to hide? Why not tell us? We know you hid the fact that you were getting phone records from members of Congress. We want to know why this payment had to be hidden. Why couldn't you just contract, which would be the customary normal way, I think, of doing it?
I did not make the determination that this source would be confidential, but given that this person was working on an investigation involving attacks on the Capitol, and given the violence in that, it makes complete sense to me that the Bureau would.
You know of any of the other special counsels who approved payments to like I don't remember Robert Mueller approving payments to confidential human sources. I don't remember Durham. I don't remember her. We brought all those guys in front of the committee. It's the first time I've ever heard of a special counsel having to pay secret money to someone to get information when you had the broadest subpoena power you could possibly have. You aware of any of the other special counsels who had to do this?
I am not aware whether confidential sources were or were not used in those investigations.
That's because I don't think they were. I don't think they were.
I'm not aware one way or the other. I can say that the use of confidential human sources is a standard thing done by the Federal Bureau of Investigations.
The time of the gentleman from Wisconsin has expired. I now yield to the gentlelady from Georgia for 5 minutes, Ms. McBath.
Thank you, Chairman. And Mr. Smith, thank you for appearing today to speak publicly about the major issues that you handled as special counsel. Your work on election interference in my home state is especially important, as Georgia still today remains ground zero for voting rights. My state has a long history of voter suppression, including violent tactics and legislation that has actively disfranchised our voters. In fact, the Department of Justice filed a lawsuit against Georgia in 2023 challenging recently passed voter suppression legislation. That lawsuit was later withdrawn by Donald Trump's Attorney General, Pam Bondi. But this is not the first time that Donald Trump has encouraged voter suppression. In the 2020 presidential election, which many have accepted that he lost, he pressured his party members to overturn a legal election. Thankfully, several public servants upheld our constitutional process and respected the voice of the people. Your investigation revealed how far he is willing to go. In your final report, you wrote that, and I'm quoting, "The through line of all Mr. Trump's criminal efforts was deceit, knowingly false claims of fraud." Mr. Smith, what did your investigation reveal about President Trump's interactions with Georgia's officials regarding his frauds claims?
As I sit here now, I can recall two specific officials. The first was the Secretary of State, who was a fellow Republican. My understanding, he voted for and supported Donald Trump in the election, but told Donald Trump in a conversation that was recorded in no uncertain terms the results of the election, and debunked many of the fraud claims that Donald Trump had to him in real time. In addition to that, I recall that Donald Trump also spoke firsthand with the Attorney General of your state, also a Republican, who informed Donald Trump that he had supported him and voted for him twice in the past. He also told Donald Trump he did not see outcome determinative fraud in that state.
I have an audio from a phone call between Trump and the Georgia Secretary of State regarding the 2020 election. Could you please play the audio?
Are angry. The people of the country are angry, and there's nothing wrong with saying that, that you've recalculated.
Well, Mr. President, the challenge that you have is the data you have is wrong.
So, look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have, because we won the state.
Mr. Smith, you explained in your deposition that Georgia Secretary of State was one of the witnesses who disabused President Trump's false claims. How did Georgia Secretary of State push back against Trump's efforts?
I think my recollection is in this same call, President Trump repeatedly raised fraud claims, and the Secretary of State repeatedly explained not only that they weren't true, but I believe my recollection is in several instances explained why they weren't true. And I believe that call ended, my recollection is that it ended with President Trump, in essence, threatening the Secretary of State that he might be a target for criminal prosecution if he didn't do what President Trump wanted him to do.
So, see, that raises a very critical point. President Trump didn't just spread lies about the election. In your words, and I'm quoting, he preyed on, end quote, Republican officials in Georgia and other states who believed would help him. Mr. Smith, Donald Trump thought these officials would break the law out of party loyalty. And when those officials, his own political allies, told him the truth, he dismissed them and continued to spread the lies anyway. Is that correct?
That is correct.
Mr. Smith, if your case had gone to trial, would the evidence from Georgia have helped prove that President Trump knowingly engaged in a criminal scheme to overturn the 2020 election?
Yes. After an investigation following the facts and the law, we believed we had proof beyond a reasonable doubt to prove those charges.
And in your deposition, you mentioned a fake elector witness in Georgia who you thought would have been a very powerful witness at trial. Can you tell us a little bit more about that in a very limited amount of time?
Sure. It was a witness who had been made to understand that his electoral vote, his alternative electoral vote, would only be used if they won in court, if they won in litigation. That didn't happen, and President Trump and his co-conspirators tried to use those alternative fake elector certificates to get Mike Pence.
Mr. Chairman, regular order.
Himself.
Okay, well, Mr. Smith, thank you so much for the work that you and your team of career prosecutors have put forth in uncovering this evidence. The American people need to know what happened, and they need to know how their president pressured Georgia state officials
to
overturn their free
Gentleman
and fair
from
and I
Alabama has a unanimous consent request.
Thank you, Mr. Speaker. December 6, 2025, Atlanta News First. Fulton County admits to verifying 315,000 votes in the 2020 without poll worker signatures. I yield back.
Without objection, the chair now recognizes for 5 minutes the gentleman from Arizona.
Thank you, Mr. Chairman. Mr. Smith, isn't it true that for a federal criminal conspiracy charge, it requires more than one individual? In other words, you're making a contractual agreement of some kind with somebody other than yourself, right?
That is correct. There has to be an agreement.
And so when you made the determination to charge President Trump with conspiracy, you surely knew that you had somebody else that he must have agreed upon somewhere to engage in this act that generated the conspiracy, right?
That's correct. We alleged specific individuals in the indictment as co-conspirators.
And so you knew who you were going to do who you were going to charge when you pursued the indictment. You knew who the agreeing parties were, but you chose to list them as co-conspirators, but you didn't indict them. How often have you done that in the past?
In the past, I have had a number of cases where I have charged some members of a conspiracy and not charged others.
One member of the conspiracy. How many times have you done that? Charged one member of the conspiracy and let everybody else off the hook?
I'm sure that's happened. That is not an.
You don't remember doing that?
That is not an uncommon thing to do in an investigation. In my view.
So okay, I dispute that, but we're going to leave that as it may. But let's just get to this: if a member of Congress moves to decertify a state's electors, that would not be a crime, would it?
When you say to decertify,
you make a motion to decertify on that January 6th. That way, every 4 years. That's not a crime, right?
Correct.
And if another elected official urged someone to join them in that decertification, that's not a crime either, right?
As you stated, it's not.
Several members of Congress get together over breakfast. They say, this is the normal path. We watched it because we saw the Democrats do it for every Republican president. So we're not sure how to do it. We've never done it before. That's not a crime to sit down at breakfast to talk about that or any other time together to talk about decertification, is it?
No, it's not a crime to talk about that over breakfast.
In your deposition, you talked about, you made the argument that an elected official who's been deemed to have lost could not knowingly make false statements about election fraud to target a lawful government operation. Isn't that true? That's what you said in your deposition. Page 27.
I believe it's a lawful government function.
Yeah, I'm sorry. Yeah, lawful government function. That's what you said. You remember saying that?
I said lawful government function. Could you read back what you said again? I'm sorry.
Yeah. An elected official has been deemed to have lost could not knowingly make false statements about election fraud to target a lawful government function. You said that would be illegal. Remember that page? Do you want me to actually read this back? Surely you remember that position.
I'm not denying it, and I apologize. I'm just trying to listen to you closely.
Okay, let's just go right from this. You said there's, as we said in the indictment, he was free to say that he thought he won the election, right?
That is correct.
He was even free to say falsely that he won the election, correct?
That's correct.
What you said is he was not free to do was violate federal law and use knowingly false statements about election fraud to target a lawful government function.
That is correct.
Yeah, and for you, that lawful government function is the certification process, I suppose, on January 6th.
Well, it's a slightly broader than that. It's the collecting, counting, and certifying of the votes. Our view of the evidence is that begins from the point of time that the electors are certified through the counting of the votes. So that would be
the entire certification process from the state to the feds.
My recollection, as it's pled in the indictment, as I sit here, I don't have it in front of me, but I believe it's from December 14th. I think that was the day through the voting.
Okay, so you can't recall, but for you, it's from the certification moving forward to the actual ratification of the certification process on inaugural day.
My recollection, that's what we pled in the indictment. Yes.
Okay, so you've managed to filibuster us right out of this thing, but your beef was you said that President Trump engendered a level of distrust. You said he made false statements to state legislators, to his supporters of all sorts, and somehow you discerned that his supporters were angry and that was somehow related to a criminal offense. I find that absolutely weak. I think it's misdirected. And
Time of the gentleman's expired. Gentleman yields back.
Mr. Chair, I ask unanimous consent to enter into the record. Axios dated August 2nd, 2023. Barr says Trump's First Amendment argument in January 6th case is not valid.
Objection? Did you have one? Okay. Gentlelady from North Carolina is recognized.
Thank you, Mr. Chairman. Mr. Smith, many of us were here on January 6th and directly experienced what happened. Yet some of my colleagues across the aisle still insist that Trump had no role in the violence. In videos of the raging battle against our brave Capitol Police officers, many rioters were screaming things like, "We were invited here by the president." Mr. Smith, did your investigation uncover evidence that some of the rioters had gone to the Capitol because they really believed the president had invited them there?
There were, I believe there's video of rioters saying, in fact, that, and as we pled in the indictment, the knowing lies that Donald Trump put out in the weeks leading up to that led to a level of distrust, and he ultimately knew that the crowd at the Capitol, or at the Ellipse, I should say, was angry before he told them to march toward the Capitol.
And we've seen report after report of rioters who have said that if Donald Trump had not convinced them that the election had been stolen, they might not have even come to Washington. I'm going to share some quotes from some of those rioters. "I believed I was following up on the instructions of former President Trump," one rioter said about going to the Capitol. "I marched to the U.S. Capitol because President Trump said to do so," another said. "He personally asked for me to come that day," said another.
Can you give us a few examples of Trump's rhetoric and language that inspired people to go to the Capitol believing that they were going on the president's direct order?
One instance I can recall is during the speech he gave to his supporters, and in context, his supporters, he told them to come to Washington, D.C. and be wild. He was on notice that they were angry, and he told that crowd, we can't let this happen. And he told them that, my recollection is multiple times, at a time when there was nothing that could be done to stop the outcome of the election, but to obstruct it. In addition to that, he told them when there is fraud, you can go by different rules. And my recollection is there is a videotape of when he's making these sort of statements and he's saying that they need to fight if they want to save their country. There are, in fact, people in the crowd chanting, "Fight for Trump." That all happened during the lip speech before people headed towards the Capitol and the Capitol was attacked.
And did your investigation find any of the rioters trying to use Trump's words and calls to action as a defense in the criminal cases against them? I can read you something from your special counsel report.
I was just going to say, I think we cited a number of rioters who ultimately admitted that they had committed their crimes at the behest and in the name of Donald Trump.
Okay. And it happened several times, and many of those accounts are on page 86 and page 87 of the special counsel report. Even the lawyer for Jacob Chansley, also known as the QAnon shaman, highlighted that his words, how the words affected his client. He heard the words of the president, he believed them, he genuinely believed them, and he thought that the president was actually going to walk with them to the Capitol. For my final question, Mr. Smith, do you believe that Donald Trump motivated and was responsible for the violence that occurred on that day, even if he didn't walk with them to the Capitol?
Yes, as we stated in our report, the results of our investigation following the facts and following the law was that he was the person most responsible for what happened at the Capitol, and that he caused what happened at the Capitol, and that it was foreseeable to him.
Thank you. Mr. Chairman, I have two UCs.
Joan, can state her unanimous consent request.
I asked unanimous consent to enter into the record a tweet from Representative Biggs on January 7th, 2021, in which he said, quote, "Yesterday, criminal rioters hijacked a joint session of Congress."
Objection. Without objection.
And the second one is a unanimous consent to enter into the record an interview from March 2024 on the Capitol Hill show, in which you called on those who attacked the Capitol on January 6th to be, quote, held accountable because, quote, that's the way our system does work and should work.
Without objection.
Thank you very much. Thank you
I
very
recognize
much.
the gentleman from Texas.
Thank you, Chairman. Mr. Smith, how many members of Congress or the Senate did you subpoena phone toll records?
As I sit here right now, I do not recall a specific number.
Is this the complete list right here? Well, let me ask you this. Am I on this list? Did you target my records and subpoena my phone toll records?
My understanding is your records were subpoenaed by prosecutors before I became special counsel.
Well, the staff would put this up on the screen. I'm thankful for the great staff who discovered the email where I learned for the first time a few weeks ago that my phone records were indeed targeted. We called AT&T and we've learned that they were given to the Department of Justice, as this email indicates, because I've been in communication with Scott Perry, one of my colleagues here in Congress, who literally had his phone taken from him in front of his family. And of course, as we've already talked about in this document, it talks about you could be in violation of the privilege by even obtaining and possessing this information if the member objected to the disclosure. This happened 4 years ago in May of 2022, and I couldn't object because I didn't know. I didn't know until about 3 weeks ago. My question here is, was there any limits to your investigation or the investigation that preceded you, Mr. Smith? Because as egregious as a violation of separation of powers this is, as an egregious and abuse of power it is, it's far more concerning you are clearly targeting American citizens for merely being conservative or supporting the president. We've got memos that we've already been talking about in this hearing from April 2022 that preceded you that established and opened the investigations, one of which has Attorney General Merrick Garland's signature on it. And the focus was the electors. Now, that was 6 months before you were appointed. You testified earlier, you met and interviewed Merrick Garland and Deputy AG Lisa Monaco, and you briefed the AG and Deputy multiple times. Did you brief them on the electors and the prosecution of their supposed crimes?
Did I? I'm sorry.
Did you brief them on the electors and their supposed crimes?
I don't recall specific conversations, but I'm sure that in the course of briefing them, I discussed.
Wasn't that the purpose of the entire investigation as it was set out? Because putting aside that in 1960, we've already talked about my friend Mr. Tiffany, that Hawaii put forward an alternate slate of electors, the investigation pivoted to President Trump and, frankly, anybody who knew him. Do you know who Cleta Mitchell is?
Yes, I do.
She's an election lawyer that was involved in filing an election contest on behalf of President Trump in Georgia in December of 2020. A 64-page complaint with over 1,100 pages of exhibits, witness affidavits, and expert witness reports documenting thousands of votes cast in violation of Georgia law, but which were nevertheless included in the vote totals. Now, notwithstanding the disposition of the cases that was filed, is that a criminal act? Filing an election contest on behalf of a candidate for office, a client. Is that a criminal act, yes or no?
No, in fact, we
So why did you deem it appropriate to monitor Cleta Mitchell's long-distance phone records in 2023, 2.5 years after the election contest was filed and after the presidential electors were certified? What about Jen Ellis? What about Sidney Powell? What about Bill Sepien? What crime did you suspect had been committed by them that would warrant monitoring their phone records 2.5 years after the 2020 election was certified?
With respect to Sidney Powell, she is one of the co-conspirators alleged in the indictment. I don't know what you mean by monitoring, sir, if you're talking.
Well, there were some 400 plus Republican conservative groups and leaders who were targeted by your investigation. Their financial records were obtained, records of the RNC, the Trump campaign, Cleta Mitchell, the Conservative Partnership Institute, the America First Policy Institute, NRCC, NRSC, PACs, conservative groups, people all across the country, citizens, because we hear a lot about members of Congress. And we should, because of separation of powers and the egregious abuse of power. But what we're not talking about enough, in my opinion, are the American citizens that have been targeted. Because frankly, are there any limits to the power of a special prosecutor or special counsel? So much so in your abuse of power that in the summer of 2024, the indictment involving classified documents was dismissed after determining your appointment violated the Appointments Clause of the Constitution, but you continued to sign your name on court filings until the time you resigned from office in January of 2025. A federal judge just recently stated a prosecutor who continues to sign his name in court filings after a disqualification order should face disciplinary action or disbarment. I yield back.
Gentleman yields back.
Did the gentleman have the opportunity to respond?
If the gentleman wants to respond, he can.
With respect to the last point, Judge Cannon's order specifically limited her finding to that proceeding. So there would be nothing improper about continuing to litigate the cases in Washington, D.C., and with respect to Florida, there was nothing improper about taking an appeal of that very decision.
The gentlelady from Vermont is recognized for 5 minutes.
Thank you, Mr. Chair. Mr. Smith, I want to discuss Volume 2 of your report, which summarizes the findings of your investigation into President Trump's hoarding of classified documents at Mar-a-Lago and his efforts to obstruct the FBI's investigation. Mr. Smith, is it generally the practice for a special counsel's report to be made public to the American people?
I want to say first, I'm limited what I can say about Volume 2 because of Judge Cannon's order. I can say generally that with respect to special counsels, there are regulations that direct a special counsel to draft a report. Whether that report becomes public is determined, the Attorney General has the authority to determine that.
To the best of your knowledge, was Special Counsel Mueller's report made public in full?
I know it was made public. I'm not sure if it was made public in full.
What about Special Counsel Herr's report?
My recollection is his report was made public in full. I believe that's correct.
And Special Counsel Weiss's report?
I do not know.
Okay. Now, I understand that the district judge, Aileen Cannon, the Trump appointee who oversaw the case in Florida, issued a gag order that prevents you from discussing any parts of the classified documents investigation that is not already public. I understand that, including your findings that you laid out in Volume 2 of that report. Am I correct that the reason your report is not available in full to the public is because of this gag order?
I wrote a report. The Attorney General, it was submitted to him. I understand generally that there's been litigation about whether this report would be public or not. I have not been a party to that litigation. I just know that there is an order, and I know the Department of Justice, the current Department of Justice, has interpreted that order in a way that I cannot speak about anything that could possibly be in that report and its findings.
And when Judge Cannon issued that gag order, she cited pending cases against Trump's co-defendants. Is that correct?
I'm sorry?
When Judge Cannon issued the gag order, she cited pending cases against Trump's co-defendants. Is that correct?
That's my recollection.
Are those cases still pending?
No, they're not.
No, they're not. So there is no reason, from where I sit, for this important information to be not made public. At this point, I want to turn now to President Trump's attacks on you. Trump has a playbook for how he handles people who try to hold him accountable. In August 2023, right after your office indicted him, President Trump shared that playbook on social media for everyone to see. He wrote, "If you go after me, I'm coming for you." Trump has said that you, Mr. Smith, should be investigated and put in prison. He called you a disgrace to humanity, a radical left Marxist, a criminal. In fact, Trump has used the words deranged Jack Smith 185 times on Truth Social. How do you think that these statements have impacted you, your staff, and your investigation?
With respect to me, I think the statements are meant to intimidate me. I will not be intimidated. I think these statements are also made as a warning to others what will happen if they stand up. And I am, as I say, I'm not going to be intimidated. We did our work pursuant to department policy. We followed the facts and we followed the law, and that process resulted in proof beyond a reasonable doubt that he committed serious crimes. I'm not going to pretend that didn't happen because he's threatening me.
And Mr. Smith, do you believe that President Trump's Department of Justice will find some way to indict you?
I believe that they will do everything in their power to do that because they've been ordered to by the president.
That's very concerning, obviously. It's very concerning to all of us, at least on this side of the aisle. This is Trump's playbook at work. Complain loudly, gin up hatred and resentment, then express our hope that somebody will do something, but never explicitly order anyone to act, and then watch as his followers and loyalists go after their targets. This is what happened on January 6th. Trump stood at the Ellipse and gave a campaign speech to his supporters, and he said, "If you don't fight like hell, you're not going to have a country anymore." And I think it's clear that his intimidation will stop at nothing. I want to speak on behalf, in closing, I want to speak on behalf
no
of
closing.
people.
Chairman, regular order.
No, I'm sorry.
Mr. Chairman,
I'm
regular
sorry
order.
you have gone over numerous times.
Time belongs to the gentlelady from Vermont. I'll let you go a couple more seconds.
Thank you, Mr. Chair.
Like I have all day.
Thank you. On behalf of the people of the state of Vermont, thank you for all of your 30 years of service to this country, and to the police officers sitting here. I'm ashamed that you have not gotten your due.
Time of the gentlelady has expired.
I yield back.
The gentleman from New Jersey is
I've got a UC request.